United States District Court for the Eastern District of South Carolina is now in session. Judge John J. Parker presiding, with Judge Wadis Waring and Judge George Bell Timmerman. The plaintiffs call W.B. Springer.
You, Mr. Springer, are Clarendon's superintendent of schools.
I am.
It is true, is it not, that Negroes in Clarendon County attend one group of schools and people who are not Negroes attend other schools?
That is true.
Why is that true?
I couldn't answer that exactly. You'd have to ask the children why none of them ever asked me to go to one school or another.
Isn't it a fact that you do it because of the state law?
It's the law, separate but equal.
And you enforce the segregation law?
I do. I know nothing but the law.
Isn't it true that you spend 3 times as much on each white child's education as each Negro child?
And we have 60-odd Negro schools and about a dozen white schools. And the rural white schools we spend less than in the city white schools.
Is it not true that you spend $179 on each white student and $43 on each Negro child?
If it pleases the court, I wish to make a statement.
What is it, Mr. Tully?
The defendants, the school board of Clarendon County, wish to concede that inequalities exist in the schools of this district. We have found this out from investigating authorities.
Mr. Tully, you can do that when you make your opening statement.
Your Honor, I thought if we were to concede this point, it would eliminate the need for lengthy testimony to prove inequality. When we discovered the inequality in Somerton's colored schools, Governor Burns proposed legislation for a state sales tax that would generate $75 million for school construction. Now, I have here architect's drawings of proposed additions and improvements to the Scotch Branch School. Now, we urge the court to allow the state reasonable time to...
Your Honor, what we see here is an attempt by the defense to prevent us from developing our case. For us to prove that South Carolina's segregation statutes are unconstitutional, we must be permitted to present evidence showing that our clients are damaged as a result of these laws. We have gone to great expense to bring expert witnesses here.
The state seems to be dealing with the problem. There's no need for us to be tied up here listening to experts.
Isn't there a larger question before us? Is the state segregation law constitutional?
No, I think we ought to hear this evidence. Mr. Marshall, you may continue with your witnesses.
I am a social psychologist and educator. I have degrees from Howard University and Columbia.
Is it true you conducted scientific measurements in Clarendon County to determine the effect of segregation on Negro school children?
Yes.
I can't hear the man.
Speak up, Mr. Clark.
Please describe, Dr. Clark, the results of your investigation.
When Negro children were asked to choose between the white dolls and the brown dolls, and to say which doll was the nice doll, 65% said the white doll was the nice doll. Every one of our tests shows an unmistakable preference for the white doll and a rejection of the brown doll. These children in Clarendon County, like other human beings who have been subjected to an obviously inferior status, have been irreparably harmed. The result is a confusion in the child's concept of his own self-esteem. This leads to a desire to resolve this basic conflict by withdrawing.
Do you believe this policy of segregation has any effect on the white children?
Yes. It causes moral confusion. The child who is part of the segregating group sees the same people who teach him democracy, brotherhood, love of his fellow man, also teach him to segregate and discriminate.
Your witness, Mr. Tully.
Dr. Clark, how many white children were in your classroom when you went to school?
None.
Has anyone ever described you as inferior? No more questions.
Legal segregation of education is the single strongest factor in causing harmful effects on the physical, emotional, and the financial status of the Negro child.
How does this happen, Dr. Critch?
The state harms an individual when it sets him apart because of the color of his skin. Legal segregation causes the Negro to feel that he is different and inferior to the white man.
Your testimony is that it can cause a false feeling of inferiority.
The sad thing is that the white man has reason for his prejudice. Our studies have shown that the Negro is inferior to the white man. We have seen
Doctor, are you saying there are biological differences between Negro people and white people?
No, sir. I know of no psychologist who would maintain that there is a fundamental biological difference. What I am saying is that the Negro can become inferior because of the practices of segregation and their consequences.
Are you saying that segregation can cause permanent damage to the individual?
I am, sir.
I have no further questions.
Professor Critch, you a native of the state of South Carolina?
No, sir.
You ever lived in one of the states that has legal segregation?
No, sir.
Has your legal name always been Critch?
No, sir.
And what was your name originally, sir?
Krzyzewski.
Were you born in the United States of America?
No, sir.
Where, in fact, were you born?
I was born in Poland.
No further questions. Mr. Crow, would you describe the position to which Governor Burns recently appointed you?
I am director of the South Carolina State Educational Finance Commission.
Your responsibility?
I'm in charge of the new program to make colored schools equal to white schools. We expect an appropriation of $75 million.
And what have you got for the schools in Clarendon County?
Sir, we've allocated $500,000 to Clarendon County alone.
Mr. Crow, when will these new facilities be ready for the children?
We hope some will be ready by the beginning of the next school year.
Your Honor, the 14th Amendment to the Constitution of the United States, an amendment ratified in 1868 by all the states, including South Carolina, guarantees rights in the present, not at some time in the future.
The court's familiar with the Constitution, Mr. Marshall.
Mr. Crow is talking about remedies that are in the future.
The court's action may depend on whether the state is making good faith efforts to improve the condition of these people. Go on, Mr. Tully.
Do you think it would be a mistake to force children to attend racially mixed schools?
I don't think you could keep things peaceful.
So you believe that mixing the races make the situation worse?
In my opinion, it would cause chaos, lead to the elimination of public schools in most, if not all, the counties of the state.
Thank you.
Mr. Crow, Mr. Crow, this new state commission of yours, are there any Negroes on it?
No.
Are there any Negroes employed by your commission?
No, sir.
Mr. Crow, how much study have you done on the question of racial tension?
I have observed conditions and people in South Carolina all my life. but I haven't studied racial tensions as such.
Then how do you draw your conclusions as to what would happen if the schools are mixed?
Because I know what people say.
You are speaking of white people.
Mainly.
You say the public schools will be eliminated if integration were ordered.
They would be abandoned.
You believe that white people would abandon their schools if forced to integrate?
Yes.
You think white people would deprive their own children of an education?
I didn't say they'd do that.
You said they would abandon the schools. Maybe I misunderstood you.
I don't think the legislature would continue to appropriate money for public schools if segregation is eliminated.
Do you think you are qualified to testify as to what the legislature of South Carolina will do in the future?
I know what people say.
You know there has been peaceful integration in certain graduate schools elsewhere in the Deep South.
That's a different matter. Those were older people, and just a very few, I might add.
Indiana has outlawed segregation entirely.
The ratio between the races is very different in Indiana.
Suppose the ratio here was 95% white and 5% Negro. Would that cause you to change your opinion?
It would not.
Then the ratio of Negroes has nothing to do with it. Your opinion is based on the fact that you have all your life believed in the segregation of the races. That is the real basis of your opinion, isn't it?
That wouldn't be all.
Would that be part of it?
I suppose that would be part of it.
Thank you, sir, Mr. Crow.
Mr. Tully, you may make your final argument.
Your honors will remember that the very same Congress that passed the 14th Amendment in 1868 also passed the law that set up segregated schools in Washington, D.C. Now, since then, 17 state legislatures have passed laws requiring segregation in public schools. Now, this practice of separate but equal has been repeatedly upheld by the Supreme Court of the United States, most notably in a unanimous decision in 1927 by a court which included former President William Howard Taft as Chief Justice and such distinguished associates as Louis Brandeis and Oliver Wendell Holmes. It cannot be persuasively argued that these great American jurists, the Congress of the United States, and the 17 state legislatures were acting in ignorance of the Constitution or knowingly defying its meaning over so long a period. Segregation is legal in education, so long as it's equal.
Mr. Tully, you have come here and admitted the facilities are not equal. The law does call for equality, does it not? Isn't the surest way to achieve equality to admit the colored children to the superior white schools?
No, sir. The problems of race, if Your Honor pleases, will not be solved by force, but rather by the slow process of community experience and mutual goodwill. And any ruling by this court must take into account the fact that school facilities cannot be built overnight. All we're asking is time.
There is no factual dispute before this court. Negro schools are conceded to be unequal. What is at issue is the law. Yes. Separate but equal has been the law of the land for many years, but the Supreme Court has ended segregation in Southern graduate schools without any negative consequences. This is progressive development of the law. In South Carolina, all the state officials are white. All the school officials are white. This is not just segregation. This is exclusion from the group that runs everything. The Negro child is made to go to an inferior school. He is branded in his own mind as inferior, which sets up in his mind a roadblock that prevents him from ever feeling he is equal. You can teach such a child citizenship. You can teach such a child the Constitution. But he knows that for him, it isn't true. Your Honor, we have shown that lasting damage is done the Negro children every day that Clarendon County operates its school system in violation of the law. The defense asks for time. Time for the slow process of community experience. I know of no statute that allows anyone to walk into court and ask for time to stop doing something which is unlawful. If the Negro children of Clarendon County are entitled to any rights as American citizens, they are entitled to those rights now, not at some time in the future. Now is the time for the court